anybody over the age of 18 needs to have some type of plan. And this is very eye-opening for a lot of families that have young adults where kids are just turning 18, maybe going off to college. They alone should have a power of attorney, an advanced healthcare directive, and a HIPAA authorization. Because what I find is that if they were in an accident and they were unconscious in the hospital, the family would have no ability to talk to the doctors and understand what was going on. And I have actually had this happen to clients where their kids went away to school and they were in an ambulance, unconscious, going to the hospital, and the hospital would tell them nothing. Right. So even from the age of 18, there are a limited number of documents to just make sure that there are legal plans in place. Right. I've had clients where the parents come to us because their adult children pass away under the age of 30, and now they can't get access to their Apple accounts, right? They can't get all of the pictures from their iCloud accounts. And so there's things and certain types of platforms make it easy to identify if something were to happen to me. Here's people that I would want to be able to log in and be able to get access to my accounts, right? So there's just things that people put off and they don't do. But especially if there's property involved, right? If there's minor children, there's generally going to need to be a will and a trust that's created that gives that information about if something were to happen to you, what are the things that you would actually want to happen. And I'm a licensed attorney in the state of California. And so probate is different in every state across the country. And so it's, it really is dependent upon your state. So it's always important to work with an attorney in your state to understand if something were to happen to me, what would happen to my assets, what would happen to my family, because there's just a lot of misconceptions. Like I just had somebody in a workshop last week where her husband was literally in the hospital and they were not planning on him going into the hospital. And they had put off doing their estate plan. And she's here going through this emotional turmoil of her husband's in the hospital. She's not sure if he's going to make it out. She's trying to get the plan done. And he just told her, don't worry about it. Everything's going to go to you anyways. And so many people think that when it is not the case, right? It depends on the assets you have. It depends on how it's titled. It depends on what your family structure looks like. And, people just think, oh, it's automatically going to go to my spouse or to my kids. And that is not always the case.
Yeah, that's very true. We've seen some instances where people have even gone out to do trust work, for instance, and they don't take the time to coordinate their financial advisor and the accounts at Fidelity, TD Ameritrade at the time, Charles Schwab, wherever they are, right? They don't make sure the beneficiary designations at those accounts and custodians, 401k plans match the document or match the verbiage and language in the trust, which is a very detrimental thing because my understanding is, I'm sure yours is too, is that whatever is on that beneficiary designation at that custodian, that is the trump card. That's where the money flows to. Now you can have that point to an individual person or your trust, all right? But that's where it goes to. Is that accurate?
That is accurate. Yes. And I had this situation happen where we were going through probate. My client was the sister of the deceased and she was the only living heir, and she found an investment account and contacted the company to get it to bring into the probate estate. And they said, we're sorry, but we've already distributed it to the beneficiary. And I call him and I said, she has no living heir. She's not married. Who could this beneficiary be? And it was the ex-husband that was still listed on the beneficiary designation from when they were married, and they had been divorced for over 22 years. And he got this money. It was over $300,000.
That's insane. And that's just one of these little things, and you can even go as far as getting your estate planning done, but not point the beneficiaries on your accounts to your estate plan. And what you think is going to happen when you pass on isn't going to happen, even though you feel like you've taken the necessary steps to make that happen. And that's one of the big things that we do at Ally Wealth is we're very focused on coordinating with your estate planning attorney and your CPA to make sure that the moving parts that we're managing for you are also moving in a copacetic way with your estate planning, your tax situation. And I think a lot of advisors overlook that aspect. Subscribe to Redefine Retirement on YouTube, Spotify, or wherever you listen to podcasts.